Okay, so I'm Cassie Harris. I introduced myself earlier, but I work at OCR in the Southeast Regional Office as an investigator. And a quick disclaimer, I don't have a technical background. You guys are all very sophisticated, and my background is in health policy and social work. So I'll do my best to answer any questions, but they're real technical. I might have to take them. Maybe I can get back to you later. So I wanted to mention a couple of sort of like current priorities, which they change a little bit sometimes, but these are sort of like big things, and I think they're important long-term, and they're going to be important to our office in our enforcement actions. Roger mentioned, Director Severino mentioned the Access Initiative. So this is important. It's sort of like a foundational patient right in HIPAA, is that patients should have a right to access their medical records. And this is important because part of the impetus behind HIPAA is that patients can be involved in their own healthcare and better and healthier because they are invested. And then the other thing that's really important to us right now is the requirement for a security risk analysis. And Roger also mentioned this. It's also foundational because the idea is if you don't know where you might have risks, how can you prevent them, right? So it's important. It's sort of like a very important beginning step to like know where your data is, know where you might have a risk, and then try and protect against it. And then I just thought maybe I could go through generally our investigation process. I thought that might be interesting, and then I can take questions. But normally what happens is we get a breach report from a healthcare provider. Sometimes we get a complaint and open an investigation on the based on a complaint. And then other times we open a compliance review based on not a complaint or a breach report, but most often this happens if like there's a news article or something and somebody brings it to our attention and we haven't gotten a breach report from a provider. So then we open a compliance review and do an investigation because of that. And then I don't know if you guys have worked with us before, but sort of the first thing that happens after we get that breach report is we call you and want to talk about it. We want to know what happened. We want to gather a couple extra details. That initial phone call is pretty important to give our investigators an idea of what's going on, right? There is a place to put a description in the breach report, but it's a really nice way to get like a few extra details and really flesh it out. And that's your first opportunity to tell us what you're doing to fix it.
Yeah, and that's, I've had clients where when they're being approached to have the phone call contacting me, so that we go over, really it's more demographic information. You want to verify that the OCR report is correct, clear up any kind of issues that may not be clear for you. So it's a fairly benign conversation for that first one, but a lot of clients are very concerned about that whenever they get that reach out from OCR as to wanting to speak with them about the incident.
Yeah, and one of the reasons that we do make that phone call is because if there's a mistake in the breach report, we want to know about it, because like fairly quickly after the phone call, that's when we publish the breach information on our website, on the wall of shame. Do you guys call it that? That's what we call it. Is that what everyone calls it?
Yes.
But yeah, like we had to make that phone call and correct, especially the categories that are listed on the wall of shame. We want to make sure that stuff is accurate, like the name of the entity, the number of individuals affected, the type of breach and location of breach. I forget what all's on there, but that stuff we really want to get right before it goes up. I will say that sometimes most often with the number of individuals affected, that sometimes isn't determined by the time the breach report is filed, because there's like a 60-day window. You have to provide us notice within that 60 days. And sometimes there's still an ongoing forensic investigation. You're not totally sure the exact number of individuals affected. Let your investigator know that during the phone call. And it sort of depends on the case, but sometimes we'll wait to publish that information on the website until we get that for sure number, because we do want that to be right. And we can change it later, but I think it's a whole thing. So, yeah.
Cassie, I have a question.
Yeah.
And I don't mean to put you on the spot.
No, that's fine.
But if you've entered a report and then have made the determination that there was not a breach.
Yeah.
How can you amend that report?
Yeah,
can you?
That is tricky. I have come across this exact example where a covered entity reported it to OCR. They were still doing an investigation, and then during the investigation, they determined actually there was no breach. There's no disclosure. There's no impermissible access. It's not a breach of PHI. There was no patient information involved. So they amended the breach before I even got the chance to call them to reflect that like 0 individuals were affected. And like, to be honest, that's a red flag. I said, what's going on? They reported a breach. Nobody's affected. I don't understand. And in that case, it is tricky. So because there's been that initial report, we have to do an investigation. And in that case, some of the things we normally ask for, like proof of notification, I didn't initially ask for because they didn't notify anyone because they determined no one was affected. But yeah, that's a tricky case. We do have to investigate the breach report when it comes in. And, you know, it was hard to explain that to the covered entity, like, you know, because they did this in good faith. You know, they reported it within the 60 days because they knew there was that time frame. And then they still had to work with me to do this investigation. But yeah, all I did was investigate and find out that, in fact, it wasn't a breach and they could provide me with evidence that there was no breach. And I think in that case, it did go up on the wall of shame and then we took it down, I think is what happened.
So you did take it?
I think so, yeah. Yeah, I try and make sure to amend because I know it's a big deal for your name to go up on this website. So I try and make sure it's accurate, yeah.
We can search it, by the way. If you give
Yeah.
us the entity, we'll look.
Yeah, everyone can look it up. That's why, yeah.
So I'm curious on the investigation side. So say you determine you want to do. Sorry. Oh, that's quite all right. So on the investigation side, so let's say you determine that you want to do an investigation.
Mm-hmm.
We have certain requirements that we have to meet. So when you do the investigation, to what additional degree do you do steps to understand what happened, why it happened, how it happened, and basically how far do you dig? I mean, without giving away trade secrets, like what, maybe give an example, or you know, do you have like work steps A, if this happened, and if you identify something, you then go to work steps B.
Yeah, I will say that's a kind of a hard question to answer because we do handle every case as its own case, and we sort of like come up with an investigation strategy for each separate breach. But you know, you get used to sort of a similar fact pattern. Like I dealt with a lot of phishing breaches, you know, and I always ask for the same stuff, you know. I'm like, I want to know what type of phishing email it was. Did someone like click on a link or did they download an attachment? Like what happened? And I think sometimes it is really straightforward and it's sort of apparent from the explanation that it's not that complicated of an issue, but other times it is really complicated. Like ransomware can be really complicated. It can be really complicated if there are business associates involved and it's not totally clear where the blame lies. And in that type of case, yeah, I got to ask a lot more questions because it's harder to understand. Is that a good answer?
It is. Having been an examiner, I understand where you're coming from. At what point do you decide to expand your scope beyond, let's say it was a phishing thing that happened? Do you go on to say, okay, well, let's start digging into all the requirements and everything that you were supposed to do?
Yeah.
Your own phishing expedition.
Yeah, I was like kind of talking to Paulette about this a little bit earlier about like when OCR decides to sort of just make a case like a little bit of a higher priority. And I do think that it's sort of a difference among investigators, what their style is. But I will say I don't like to go on phishing expeditions. If I ask you for a lot of information, that means I have to review all of it. I like to keep the scope of my investigation as narrow as I can. You know, I got a lot of work to do. I'm trying to make sure that like this was your problem and this was your fix, you know? And I think for most investigators, that's the case. You know, we're all really busy. I will say that if after we get a response from the initial data request, we get a response and it looks bad, you know, like maybe like you don't have any email policies, you know, you're not following any security for, or like, you know, your password requirement. Like I had a case where I was very interested in it initially because the provider reported that it was a brute force attack. And I'd never seen one of those before. You know, I was really curious. And it turns out this employee's email account was accessed by brute force, but her password was password 1, you know? And so like when that comes in, you know, when I get that initial response, I thought it was gonna be one thing. I got this initial response back and I thought, oh no, you know, like, and it sort of depends on what you find out. If it looks like there's a variety of compliance issues, we might like bump that case up to like a higher level of scrutiny. Or if the breach itself is like significantly egregious, like maybe a large number of people affected, or the type of data that was breached is like especially sensitive, those would also be reasons that we would sort of like make that case a higher priority. Yeah, and I will say that like I know maybe getting these data requests from us, it looks like a phishing, you know, we're just trying to see where all your problems are. I can tell you from my experience that is not the case. I don't want to see any more problems than I like have to, because then that means I have to follow up and make sure you guys are addressing all of them.
You know, and plus, I mean, the data request, it's all of, I mean, HIPAA has been effective now since 2003.
Yeah.
So we're, you know, 16 years into that now, and all of that they ask for are things that have already been in place for years.
Yeah.
You know, it's not, I mean, you know, I brought just a sample document request that OCR sends with its letter, and the entity, the privacy officer, would be the named person that would be receiving the letter. And you all know, if it's over 500 individuals, OCR is definitely going to investigate at that point. Less than 500, I think it's you all, it depends. If you've got several incidents in the past, that there's something that you can show trends, I think that you all look at that and decide whether or not to investigate. But they have this initial data request. They want the facts of the incident, what happened, how you responded to it, some of your basic policies and procedures for use and disclosure of PHI. If it was a security incident, they're going to ask for all of your policies and procedures. And what I have found, and although I don't know, I guess Cassie's take on this, what I have found is that oftentimes the covered entity has the policies in place, but being able to demonstrate that it was implemented, like your patching, you know, give me your invoices, or give me, you know, whatever reports that you have that this is going on a regular basis, you know, with, you know, just for monitoring, you know, what type of monitoring are you doing? Just the evidence of that. I think that a lot of the covered entities struggle sometimes with pulling that documentation.
Yeah, and I think that can be hard to come up with, like, how do we prove that this has been implemented? And I will say that as far as like investigations go, like HIPAA doesn't require the specific steps, it just requires the end game. You know, like you just have to meet the standard. And so whatever way you do that and whatever way you prove it to us, I mean, like the format of that evidence or documentation is less important than it actually shows something. But yeah, I think it can be tricky for providers sometimes to come up with the proof.
And you know, the security risk analysis. I mean, that is one. Smaller providers, I've seen with the smaller providers having a difficult time in having a risk analysis done. And what's even more troubling, there may be one done, but then there's no risk management plan at all, or no follow-up. One area where I've seen this being is when you're integrating new physician practices into your health systems. My experience with physician practices is that their HIPAA compliance is very minimal. You know, and so you really, whenever you're evaluating a physician practice coming in, that's oftentimes where the connections to the hospital systems, the vulnerabilities that are there. There have been, I've handled a number of clients where there have been incidents that have occurred that arose out of the physician practice and then affected the whole hospital as a result.
Yeah.
If I can, I don't want to steal time, but if I can kind of dovetail on some things you said. Would you rather see a hospital that has stellar policies, procedures, standards, and guidelines, maybe doesn't meet all of them? So in other words, they recognize the requirements and what has to be done. Or would you rather have one that basically has the skinniest of documentation, and they're maybe meeting the skinny documentation, however, it's probably not meeting all of the requirements that OCR have? Chicken and the egg, exactly.
Yeah. So I think the best way to answer that question is to refer back to the regulation, and like those are the standards, and some of them are addressable, most of them are required, and if you're not meeting them, you're not meeting them. Yeah.
I guess the question is, if I have policies and I don't practice, that's really bad.
Yeah, that's really bad.
Understand?
Yeah.
I agree 100%. Let's say that I may not have well-documented policies and processes, but the practices are there, which is hard to prove by sending information back.
Yeah.
But right, if you came in, did right, sorry, financial service background, there was not a lot of emailing of right auditors came on site, so they dug through that practice.
Yeah.
So
yeah, here's what I would.
Policies are really hard. I mean,
Yeah.
they're easy to write, but they're really hard to keep and make good. And
Yeah.
at what level, what depth? So where is that line? Is the practice more important? I think it is, but I'm not the investigator, so.
Yeah, I think it is really important if you are actually protecting information. That's really good. And maybe if your formal policy is not that good, and you get a request from us and we say, hey, we want to see this policy, and you're like, oh shoot, we don't really have that. What I would say is, like, in your response back to us, say like, hey, here's the like kind of crappy policy we have. We're working on a better one, and here's when we plan to have it, because you've identified that problem. I will say that like OCR's primary goal is compliance, and that's a really good show that you guys that you're more moving toward compliance.
Paulette's point about, I think you mentioned it first, with the acquisitions that take place all over, and a lot of times with those acquisitions, they're not near the security posture or compliance posture that we'd like to see. If there's a solid risk management plan in place, even though we can't address all of those points for 1, 3, 5 years, but we're showing kind of an evidence of getting there, how much sort of forgiveness is given?
Yeah, I will say that that's meaningful. Yeah, if you have done your risk analysis, you've identified the vulnerabilities, and you said, look, here are our priorities. This is where we're most vulnerable. This is what we're doing first. We know that there are other vulnerabilities. Here's our plan. That's really meaningful. Yeah, I mean, yeah, it's unrealistic to just like to be compliant, especially when you acquire a practice that's kind of doesn't have everything up to speed. And so, yeah, it is very meaningful to say like, look, we knew when we acquired them, we did this analysis, we know their problems, we're working on them, and here's our plan.
Yeah, just make sure that the authority has been delegated, and so that folks know what they're responsible for with that. No, that's a biggie. I found OCR to be very reasonable to work with. I mean, yes, the agency's compliance driven, but they will look at. I mean, you do look at the size and scope of the entity and take into consideration as far as the complexity of what your processes are, your policies that you've got in place, and so forth. And they are very reasonable.
Thank you.
So to follow up on Craig's point, I came from financial services as well. As much as we dislike
bank examiners, you knew what you were getting basically every 2 years, and that creates some uniformity in basically all banks. I think when it comes to OCR, you don't see many audits and that type of thing.
Yeah.
Do you know, is there any forward-looking plan that might have a more proactive assessment process?
Well, we did have an audit program a couple of years ago. I know I worked on something that was like an audit of providers.
I know they
Yes.
outsourced some of that as well to like
Yeah, I think it would be nice to do regular audits. We don't have the manpower for it. We don't have the resources to accomplish that. Yeah, which is unfortunate. Like what we do now is we respond when there's an issue, and that's not great.
So both banking and in insurance, they just bill the companies, and you get a bill for.
No, FDA does that already too.
We don't have the big pot,
Now, do you have your audit available online for providers to?
I think there is some
audit
information
protocol.
online.
The audit protocols are online.
Yeah.
Yeah, phase 2 audit protocol.
Yes, yeah. And it was sort of specific to certain regulatory standards. I think it wasn't like everything. We sort of specifically targeted certain requirements, if I remember correctly.
The HIPAA security rule, like you can go line for line, and theoretically, it was exact.
It was exact, yeah.
I think KPMG developed it, and then Fazio, they were the folks that actually executed it. But as I understood it, and correct me if I'm wrong, the audits were just there for information purposes, right? So OCR, HHS wanted to identify what are people struggling with, and none of it was used to penalize or to investigate. So any findings
I think
used just for information.
That was
purposes.
first.
that was the first. Yeah, there
one.
was a second level where we did open some investigations. So that's what I did work on a little bit. I had one case, one audit investigation. It was a small insurance provider who basically he was in like a rural, anyway, yeah, he needed a little bit of help because he's like a small rural insurance provider and like wasn't that familiar with the standards. So, but I think that investigation was mostly resolved with technical assistance, and we sort of like helped him to implement some standards. And then I think he closed his business. He was retiring anyway, so.
That's a way out.
Yeah.
Go fishing.
It was yeah.
So question on the documentation and kind of preparation, right? So it sounds like there's some documents that, and Paulette, you alluded to it, here's the kind of standard checklist that they're going to ask. They're going to ask for if there's an investigation.
Yeah.
And then
Yeah,
what you said,
I was going to say, like, yeah, you can pretty much expect us to ask for certain things. Definitely, we're going to ask for evidence of training. Because I know they talked about with the Verizon breach, whatever that was, like almost all the healthcare breaches are user error or errors caused by errors. And so, yeah, it's sometimes they're honest mistakes. Sometimes, it's a nosy nurse. It's not necessarily malicious. But yeah, what we want to know is that you have these policies and procedures, but we definitely want to see that you're training your staff to sort of prevent these breaches. And then also it's likely that if it's a security rule breach, we'll ask for a risk analysis. Not in every case, but that's that's pretty common, is that we ask for that information if it's a security rule issue.
So theoretically, folks can save themselves a little bit of anguish in terms of fire, if you went through the fire drill, of having that stuff kind of buttoned up in a package.
Yeah,
right?
That should be ready. I mean, I think also, those risk analysis, they can be quite an undertaking too. So if you can show us your most recent risk analysis and let us know when you plan to conclude the next one, or yeah, but you can be pretty certain that request is going to be coming.
And with the rule, it states that you can go back 6 years. So you need to maintain documentation for the prior 6 years. Not that OCR initially asks for that, because I know, and you mentioned the most recent risk analysis. Now, if you get a risk analysis, this is 2019 and it's dated 2015, you're going to ask if there's anything subsequent. I'm sure with that.
And then also, if we get that response back, just like one from 2015 and it's 2019, we're probably going to ask, is there anything newer? And also, we want to see all of them.
Yeah.
We want to see
Yeah.
all of them
Yeah.
that you have on file, because at that point, there's a
It's a red flag.
It's a red flag about maybe there are security issues they're not taking care of, and we want to know if those have been identified in older risk analyses and then continue to be issues. Yeah, I think that first response back to us, it's an opportunity to show us that you're well organized, you have things under control, and you're doing your best to meet the compliance standards. And I will say, mostly we work with covered entities. We do want to cooperate, and some cases do go to formal enforcement, and that's just how it goes sometimes. But most cases don't. Most cases we resolve informally. So we do go on site. I will say not often. In my experience, we most often show up on site when someone has been uncooperative, and they're not responding to us, and at that point
in Hawaii.
Yeah.
The providers in Hawaii.
Yeah, that they're not in the Southeast region, unfortunately. But yeah, that's, in my experience, mostly the reason we would go on site is because we can't get information any other way. They're just not responding to us. Or we also handle civil rights investigations, and if somebody complains about like physical access, then we would go on site also for that type of, we have to measure the wheelchair ramp,
So based on the resolution agreements that have occurred to date, about 60%-ish have a risk analysis finding associated with them.
Yeah.
Corrective action that says you need to start doing this better. One of the things that we've seen, and I hope you can speak to this, is that folks are under the impression that you have to do like a complete formal risk analysis every so often.
Mm-hmm.
But the guidance from HHS is actually saying you can build a continuous risk management process where you do maybe a full project, a formal risk assessment, but then you're doing reviews. Mm-hmm. And as long as you can show that as the environment changes or factors change, that you're actually looking at them and analyzing them and taking action on them, that's sufficient. Yeah,
I think the risk analysis it's a tough one. The standard is that you do a thorough review of your data, and then the risks, and then the level of risk, basically. We get a lot of really bad risk analyses. We get, and I don't even have a technical background, but I can tell a gap analysis when I see one, which is like, do you have a privacy officer? Yes. Do you have a policy about email? Yes. And that's not a bad thing to do, but it's also not a risk analysis. We do, I think, find we collect a lot of penalties for risk analyses. And I can say that I think in most cases, that's because they're bad. Like if you can show that you understand you read the regulation and you know what it's asking for, which is like, where is your data? Like that's missing from so many risk analyses that we see. And how do you know where the risk is if you don't even know what you're holding, And I think sorry, I lost track of your question a little bit. We do, if it is like, looks pretty good, any risk analysis that like, I can't tell is bad, and I'm like, this looks pretty good to me. We do usually send those to security matter experts in our office. And I think now most regional offices have their own sort of in the region. And those guys sort of like are the experts. They like mostly what they do is review providers' risk analyses and decide whether they're good or like where the problems are. And they are like the technical minds. And they're real smart. And I think Nick Heasters, he's going to be talking either later today or tomorrow at the conference. And he's like the head, we call them SMEs, subject matter experts. Yeah. But yeah, that's what we do normally with like a risk analysis that like looks pretty good. We send it to them to review. And I will say, I think they have pretty high standards. Yeah.
Yes, you can go from small, right, risk analysis, which could be good, could be not, to extremely, you'll be doing it for 400 years. Right?
Yeah.
Going up to entire government agency, top secret, et cetera, et cetera.
Yeah.
So where's that guidance to say this is good versus not? I'd rather know this is what a good one is
Yeah.
now
Yeah.
than later, right?
Yeah, there is.
I don't like to reinvent the wheel, but I don't have to.
Yeah, there is guidance out there that we've published. I think maybe Roger mentioned it earlier, the newsletter series. We have like a security newsletter. There is one specifically that's risk analysis versus gap analysis. And I mean, that's just like, I think basically tells you like, don't give us a gap analysis, that's bad. And then I know we work with the NIST standards in our review, although technically our standard is the security rule text, like that's our standard. If you're doing, and it's not specific, right? Like all those standards are supposed to be scalable depending on the complexity of your practice. And so, yeah, it's hard. We don't have that like specific guidance. I know they put out a tool recently and then I think they took it back.
Don't get me started.
Yeah, I know.
Don't get me started.
Yeah, there is. I mean, I'll say I refer to that security rule newsletter series one about the risk analysis, gap analysis pretty frequently, and that's normally enough for like me to look at a covered entity's response and be like, okay, this is bad, or this is pretty good. I'll send it to the SME to take a look. Yeah.
There's a security rule 101 series.
Yes, that's
series, and it's got prescriptive what OCR wants.
Yeah.
And a lot of it's referenced in this, but
yeah. But I will say, if you can like show us that you're meeting the regulatory text, which like the regulatory section is probably only a few sentences long, and if you're submitting something and you can make an argument that it is I think it's like a thorough assessment of risks and integrity, whatever. If you can like show, explain to us how you're meeting that standard, I would be willing to work with a provider to, if they can make a compelling argument that whatever they're submitting to us is meeting that standard for risk analysis, that would mean a lot to me.
So Cassie, I mean, everything I've seen and heard and other folks at OCR that I've talked to, I mean, you have to really go out of your way to not doing any due diligence, right? I mean, to be screwing up for OCR to say, okay, we're going to fine you, we're going to penalize you, we're going to take money out of the healthcare system, because something needs to happen. You're not doing it at the drop of a hat.
Yeah, I would say that. I mean, you guys all know we put out press releases every time we collect penalties, but so many of our cases we don't do that formal enforcement. So often all I do is like work with providers and I say, hey, what's your plan to fix this? And if it sounds good enough to me, I'm like, all right, show me what you did, maybe if I might like point out an example that I've identified from their response, and I'd be like, hey, you submitted this like records of training, but the person that owns your facility, they haven't done any training, like they're not included in this list. And they'd be like, oh, and then I'm just like, well, just get them to do some training and send it to me, like that's all. I will say that mostly we work with people, although, I don't want to make any false promises. If you've had an egregious breach happen, at your facility of your patient's information that you're charged with protecting, civil monetary penalties they happen, and that could happen.
What are some of the from the other side of the desk or other side of the table, the provider side? What are some of the challenges you see and obstacles you see when you're, either before something happens, you're walking in fresh, hopefully before an incident has occurred, or after an incident? What are the things that you see that are really, okay, these are the things consistently biting people?
Actually, usually the way it works out with me and with my law firm, we have a hotline number and with a number of the insurance, cyber liability insurance companies. So typically, for you all, whenever you all have an incident, report it to the cyber liability insurance company, and they will get you set up with legal counsel and forensics, and for whatever you need as far as to address the breach or address the incident. And we really, I mean, there are some hospitals that'll start an investigation on their own without getting outside counsel. That's fine. I recommend that if, that if any of you do something like that, that you at least you have in-house counsel, that you can at least have them involved to have an attorney-client privilege, so that, as you're going through this incident, that you can protect what you can. And here I am talking in front of Cassie, where they would argue that all of it is, is relevant and producible. But the facts of the incident, there's no protecting that. The only thing as far as with attorney-client privilege is that, anticipation of litigation or of a regulatory investigation is to, where you look at where your risks are and your potential liabilities, enforcement concerns, and, you have a plan as to how you're going to attack that and address it and so forth. All of that is privileged conversation that you have as far as, whether or not you even have a breach, what are your risks if you have, so for example, like a ransomware incident, but there's not been any access or exfiltration. You can show that with a ransomware incident while you don't have a breach. Well, of course, OCR has their guidance, and so you take into consideration a couple of other extra, whether or not patient care has been affected, whether or not you had to, the integrity of the data, and so forth. So you have those types of conversations, and I would say those are all attorney-client privilege, determining whether or not, this is something that we should be notifying individuals for. Is this something that we feel, secure enough with it, that we've got enough forensics evidence to show that there's not been a breach? Those kinds of conversations should be carried out under ACP, so that you protect that. Some of the things that I see as far as with that, carrying out an incident before you get counsel involved, that's not protected. Conversations among folks who, may not necessarily be involved, but they may be, IT person or something, they're just offhand comments. You want to really kind of avoid some things like that, because, they don't really have all the key facts to what may be occurring. Maybe just a short piece of it may have, some animosity towards the organization, and may say things that are not in the best interest of the organization. So you want to make sure that you've got a handle on that. With the incident itself, as far as the ACP, you want to build your documentation of the incident investigation and the findings. Those are asked for, and incident reports asked for by OCR generally for that, and the facts concerning the investigation. So that is important to maintain that. Like I said, we want to have that under ACP, because some of the documents that I've seen from folks, well-intended, but there can be some very damaging information that can be placed in there if you're not careful with it. So, so that's one area. Again, looking at it, if we know that it's going to be a large notification, then I like to, I keep these sample request forms whenever OCR sends out one to a client. I'll scrub it so that, there are no identifiers there, but I'll give that to a client and say, these are the types of things OCR typically asks for. They may ask for some different things based upon your facts and circumstances, but, make sure you have these ready, because they're going to be, within a month or so, they're going to send a letter, and we're going to have, 30, 60 days to respond back to them with that. Generally, the first is the document request and sending that. The OCR will go through that. During that time, if you've identified where we've worked through this and you identify where you do have some vulnerabilities or some areas of noncompliance, work on correcting that, because OCR will, if they identify them, they will come back and they'll say, what have you done? Well, it's better for you to say, blah, 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 based on this, we are now implementing, and here's our timeline for implementation of this. I think OCR looks upon that more favorably than just sending this and waiting for OCR to say, what are you going to do?
Yeah, it's nice when it's already been fixed.
Yeah, I mean, you identify that you've got an issue, take some action to correct it beforehand, so that, there's nothing left for OCR to have to do afterwards. And these are, and I'm saying these are, your good corporate stewards who want to do good. I mean, I've had certain clients that they don't have anything, and it's really hard to pull that together. And I think that's a different set where some of those resolution agreements come into play with, not only the non-compliance, but the not cooperating with OCR. And they, you don't cooperate and you're in good faith, they can take some very serious action with that. And so that's what I like to see, is if you're cooperating in good faith, and it is a good faith that you want to do to have the security and so forth, I think OCR looks at that favorably as far as, how they pursue it. But, getting back to your question and your SMEs, so after the first round of sending it in, it could be anywhere. I mean, we could wait anywhere from 6 months to 18 months, 2 years to get a response back from OCR. I think with the change of administration, there were some lapses in things that, as far as, follow up. And so there are a number of matters that I still have outstanding from 14, and that still haven't been closed out by OCR or haven't been in additional inquiry. I think that's good for the most part. I mean, if they're not knocking on your doors,
Maybe so.
But so that if there's any questions or concerns or red flags that are raised from that, and there's sometimes, we try to submit the response in the best light, but it is what it is, and the facts are what they are, and there's nothing that you can do about that. And so with the second round, OCR will come back and say, what have you done? We need additional information. You haven't supplied enough as far as what your patching policy is or whatever. Show us what you're doing. And that, really that gives you an opportunity. If you don't have those processes in place, or if you want to do, you've got something in place, it's a good opportunity to get in there and do that corrective action and report back to OCR. This is what we've done, or this is what we're doing, and this is our timeline.
One quick question for you, Paulette, is last year, whenever we had the last session, and you came in gracious enough to give us some time, you had mentioned that based on your experience, that the actual CMP, the civil money penalty, is some percentage of the aggregate cost of the incident that you've seen with providers. And I don't want to put words in your mouth, but I want to say it was like 25 to 30%.
No, I don't think I said that.
Okay, there's someone that looked like you.
They have, and that may be, but I think that there are such a variety of factors that go into it, because the size and scope of the institution and what their financial strength is. There was one, and I can't remember what entity it was, but it was one entity that had a resolution agreement and a penalty, and it was not that much, but it was because that hospital system was operating in the red already. So, there's something that, so OCR will factor in those different situations into the penalties.
Yeah.
Well, and let me rephrase my question, I guess, is what percentage of a total cost of a breach, and in aggregate for an organization, enterprise, is typically a fine from OCR? Not saying that it's going to happen every time.
Right,
Less than
but what
percent? Right.
but you're saying is like, I don't think I could answer that. Maybe our data privacy book has it.
You mentioned informal and formal investigation. I think the second that you called.
Okay.
That's formal.
Yeah, that's.
Maybe I'm just different, but what's the distinction there?
Sorry, I think I'm making a distinction between a case that gets resolved with penalties and a resolution agreement, and a case that gets resolved with a closure letter. That's my distinction. But yeah, sometimes we do go through because the collecting the penalties and doing the resolution agreement and the corrective action plan, that stuff, there's like a negotiations period, there's like a lot of drafts of these different agreements, and so sorry, that's just like my mental distinction between like
really the difference with the OCR, they've always said, and that's why we had a conversation about it, that when they're inquiring into a breach, that's an informal process. And there's a provision in the regulations of cooperation, that the entity has to cooperate with that, or it bumps it up into a formal process.
It's a factor that we consider.
Yeah. But then how you typically go through, and the way OCR has typically worked through the past, is you've come and either you have a closure letter that, no findings, or there may be some findings that just technical assistance, and then you close it out with that.
Yeah, I think most often we close out breach investigations in like, when it doesn't go to CMPs, we close them out as like corrective action is one category, or technical assistance, or finding no violation. And it's just, yeah, it's maybe like a 3-page letter or a 2-page letter that's like closed.
But then if OCR does have findings and it wants to pursue penalties, then they have to give the entity a notice of deficiencies and an opportunity for a hearing. So that's where so when you get that notice letter of deficiency and the opportunity, that's where you bump into the formality of it. But I will have to tell you that, and Cassie and I talked about it a little bit earlier, that if any of you have gone through an OCR investigation within the last 2 years, the notice letters now look like a civil investigatory demand letter. They want legal formality, bait stamping of all the documents so that every page you submit has now been numbered and can be cross-referenced back, so that if it bumps up into so that when it bumps up into the formality, you've got the evidentiary documents right there. But that is something that OCR is doing now. But what we had talked about is that with some of the smaller providers and smaller covered entities, that it is a huge economic impact, because the first one that I did, whenever we got that, I think I must have added on about at least 6 or 8 hours legal work just to be able to comply with their procedural requirements.
And I will say, like, you get a feeling for these breach reports, like how serious of a investigation it's going to be. And if I'm working with somebody and it seems like a pretty straightforward breach that's going to close with some corrective action, and they have a question about the bait stamping, I will just tell them, like, don't worry about it. Just send me a response that I can understand. Send me something that makes sense. It's organized. I can find what I need. And so I think if you're working with a smaller provider and it is going to be cost prohibitive, it's worth asking the investigator assigned to your case if there's some flexibility with those instructions for the response. Not that I don't want to, like, I don't know for sure how other investigators or even other regional offices, how strictly they followed, required those instructions to be followed. But
well, I found where the initial request was very formal, but then the subsequent requests were not.
Oh yeah, that's my procedure as well. We always send this formal letter for the initial data request, and then I will email. I'll be like, hey, I have a quick question.
Yeah. So so that for me, for in the law firm, we try to keep that all formal then, so that we maintain that. But that does happen sometimes. Just I do want to make one comment just about state law. For breach notification, HIPAA, you have 60 days. Well, there are a number of states that are moving towards that already have 30-day notification, or moving towards that. So in Indiana, although Indiana does not have a time period stated in their law, the AG has taken the position that reasonable time for notice is within 30 days. They have a HIPAA exception in their regulations, but if you have any employment information, social security numbers, or so of any of yours in Indiana, then you have a 30-day. Colorado's 30 days. I don't think there's anybody in here that has entities in California, but so you may want to look at your incident response plans and see if, as far as narrowing your time to.
Just point out that actually in the 24-hour notification for Medicaid.
And you need to be careful with Medicaid, and then their own agencies and schools are really kind of unusual too. But you also need to be aware of if you participate in the Medicare shared savings programs through an ACO, there's a 24-hour contractual notice to Medicare if there's a breach as well. Yeah.
There's 3 days in some of the other states.
Yeah.
Ohio's the only one that's 60 of the states that we're in.
All right, so we're right up against the half hour. I want to thank Cassie and Paulette for we're going to go around, assuming you'll be one of the chat more.
Yeah. Any questions you have, I will try my best to answer.